So, thank you all for joining us. This panel is organized through Solutions U, which is a project of the Solutions Journalism Network. It's a nonprofit organization that works to rebalance the news so what we read, hear, and listen to each day is not only problems, but also solutions. My name is Megan Kamerick. I'm a fellow with the Solutions Journalism Network, and today we're going to talk about one particular policy idea that's becoming more common as people search for solutions to gun violence. Extreme risk protection orders, also called red flag laws, have been getting a lot more attention since the Parkland, Florida shooting in February 2018. And the idea is a little bit like a restraining order. Each law varies by state, but generally they're written so that a household member or a law enforcement official can petition a judge to remove someone's firearms if there's evidence this person is posing a threat to themselves or others. Some advocates working to curb gun violence have seized upon this idea as a possible way forward in a country that seems impossibly divided right now over guns. However, there are some gun rights advocates who are still leery of authorities seizing anyone's guns. The laws are also not foolproof. Their success in stopping homicides or suicides depends upon how well they're implemented and if people understand them. I'm joined today for this panel by Jess Aloe. She's a reporter with the Burlington Free Press in Burlington, Vermont. Dr. Jeffrey Swanson is with Duke University, who has researched gun violence and these laws. And Kimberly Wyatt is Deputy Prosecuting Attorney for King County. Also here are my fellow Solutions, I should say King County near Seattle in Washington State, which does have one of these laws. Also here are my fellow Solutions Journalism Network fellows, Marie Van Hoften and Emma Zahner, who also put together this presentation along with me. And I want to start with Kim Wyatt. Kim, the Washington state law that created extreme risk protection orders was approved by voters in 2016. According to the Seattle Times, as of May this year, 2018, Seattle police had seized 43 guns from people deemed to be a danger to themselves or others. Could you tell us briefly how the law works and what your role is in the process?
Sure, I'd be happy to. As you said, this is a citizens initiative that passed the legislation in 2016, and it is designed as a temporary court order, a civil order, to prevent access to firearms and concealed pistol license for individuals that are exhibiting a behavioral health crisis, specifically threats of harm to self or others, or exhibiting violent behavior. So that was the legislative intent behind the statute, was to try to intervene prior to the actual gun violence occurring. So that was the basic statute in Washington state. Since your article, you're referring to the Seattle Times article, was in May of 2018. I recently did a presentation with Seattle Police Department, and I believe they have now seized under the Washington's ERPO's law up to 90-some firearms. In the last several weeks, we've had several extremist protection orders that have came into place and have seized, I believe, 26 guns from one individual and then a handful from several others as well.
Could you talk about what your role is as a prosecutor in this process?
Sure. So my role really, and I would back up and say that this is sort of came about by default. We needed somebody in our new unit, which is really tasked with handling firearms removal from domestic violence offenders and stalking victims who have court orders to prohibit the respondent or restrained person from having access to firearms. And then also with the extreme risk protection order came about with that. So my role really was to, first of all, figure out how we're going to make this work. And I serve as a point of contact for law enforcement and family members in the community that want assistance with petitioning for an extreme risk protection order. And our unit has literally gone with law enforcement to the clerk's office to get a court's number, to go to the ex parte proceedings where we see a judge. We've tried to walk them through that process so they're confident in that, and then also appear with them at the full hearing in front of the judge and sometimes the respondent and sometimes respondent's counsel as well.
There was a report on mass shootings from 2009 to 2016. It was conducted by Everytown for Gun Safety, and it found that 42% of attackers had shown warning signs of violent behavior. So what kinds of signs are reported to your office when someone comes, they want an extreme risk protection order? And when are those deemed serious enough to actually have guns removed, to grant an order?
So under our statute, the court, by statute, there's 15 different factors that the court can consider. But I can tell you, I should back up and say the vast majority of the extreme risk protection orders that we have worked on has come from law enforcement. And usually that's out of a crisis report or some disturbance or perhaps a domestic violence incident as well. We are not seeing a lot of family members coming in, and I believe it's partly, in big part, because they don't know about the law. And then we've been encouraging family members to come to law enforcement and to petition to kind of remove themselves from some of that dangerous area of intervening in a loved one's situation, which could put them at risk as well. So we've encouraged them to go to law enforcement. Some of the signs that the court considers are threats of self-harm. So we see a lot of suicidal ideation, threats of harm to others. Usually there's a combination. When it's threats of harm to others, we've also seen the suicide coupled with that. We've also, another factor is there recent arrests or convictions for domestic violence? Because we know that the domestic violence offender is the most dangerous in the criminal justice system. So that's a factor that the court is weighing. They're also looking at prior court orders. Is this somebody who's had prior anti-harassment orders with neighbors, prior domestic violence orders, that type of thing? Or is this somebody all of a sudden who's truly in a behavioral health crisis with no prior law enforcement contacts? And then the court is also considering alcohol and drugs. Is that in play? So those are just some of the 15 factors.
There are a lot of violent people in our society who may not have a gun handy, but this law specifically addresses firearms. Now, some gun rights advocates see this as flawed. So why have a law that just targets guns rather than violence for someone who might have a knife or something else like that?
In the domestic violence context, we have orders to surrender weapons in Washington state, and we have this issue come up frequently. I mean, our focus is on removing firearms because we know that firearms in the hands of those in crisis or at the time of separation are some of the highest lethality for victims and families. So our unit has focused on firearms, but we have also tried to address with the court knives and swords and other specific weapons. The difficulty is we can't, you can say your court order to surrender knives, but they can go back out to Target and buy a knife, so it's difficult to enforce that so that's been our focus is on the firearms. But you're right. I mean, I don't know beyond that what the policy decisions are, but courts can certainly order others to surrender dangerous weapons, and we have seen that being done.
Do you believe the law has been effective in reducing gun violence in the state?
I do. As a prosecutor, it's such a unique opportunity to come in prior to the actual crime occurring. And I would say I've been with the office for over 15 years and spent most of my career working on domestic violence and stalking cases. And it's the first opportunity that we have had to be able to kind of intervene prior to the actual crisis. So I do feel it's effective. And I would also say it's pretty powerful, and I would encourage our critics to come and sit and watch an extreme risk protection order hearing, or to look at the petitions and read the basis for why law enforcement is asking the court to remove firearms. To my knowledge, the NRA or the gun folks in Washington state have not opposed this, because I believe they've looked at the factors that the court is deciding, and to my knowledge, they have been in support of this particular law, because we are trying to be, we're trying to vet the appropriate cases to go forward on.
I want to turn to Dr. Jeffrey Swanson at Duke University. Excuse me. Jeffrey, we often think about homicides and mass shootings when we think of gun violence, but there are far more suicides every year by gun than murders. You and your colleagues studied Connecticut's law, which was the first such law in the country, I believe, when it was passed in 1999. What did you find regarding suicide rates in relation to this law?
You're right. Suicides account for about 2/3 of all of the firearm-related fatalities in the United States. And so it's kind of interesting because the Connecticut law, as well as a number of the others that have been passed in more recent times, have been passed as a legislative response to public outcry over a mass casualty shooting. But as the laws are actually used, And Connecticut is a good example from our data. They're used most frequently where there's a suicide concern. It's about 60% of the cases. And so what we found, and you know, in Connecticut, it was 1998. There was this terrible shooting at the state lottery headquarters, and then 1999, the stakeholders came together, and this law was enacted, and it was deliberately focused on behavioral indicators of risk and not on mental illness per se, so that, you know, it would not be stigmatizing to people with mental illness. The vast majority of them are not violent, although mental illness does have a strong connection to suicide. So what we found in a nutshell, a number of interesting things. Number one, we looked at the first 762 cases of firearm removal, and you know, these are civil court orders. It's not criminalizing. It's time limited. There is due process. But we looked at these cases, and we found, as I mentioned, 60% were suicide concerns. The average number of guns seized per person in each of these cases is 7 guns per person. So these are people who have a lot of firearms. And 46% of them, when we matched their records to the public behavioral health system, the Connecticut Department of Mental Health and Addiction Services, 46% had a record of contact with that system, although most were not in treatment at the time. 12% had an arrest either in the year before or the year after the gun seizure. So, you know, this is not a population that is heavily involved with the criminal justice system. In 55% of the cases, the individual was transported to a hospital emergency department after the police served the risk warrant. So, you know, the police go out and they've got the clear legal authority to secure the firearms and remove those, but they also find a person in crisis. So they take the person in to the hospital, and as an unintended benefit, we found that the proportion of these individuals who were in outpatient treatment for a mental health or substance abuse problem doubled from the year before to the year after the gun removal event, from 12% to 29%. When we matched the suicide or the death records, as I should say, I didn't imagine we would have very many suicides in a population of only 762 people. But we found there were 21 suicides. That was a rate of suicide 40 times higher than the general population. I think that's important legally and politically, because it shows the law was being applied to people who actually did have really elevated risk and needed the intervention. And then when we looked, there was only a small proportion of those suicides that occurred with a gun, notwithstanding these people that had 7 guns, you know, on average before they were taken away. So because we have good information on the case fatality rate of each method of suicide, both for the country as a whole and for Connecticut, we were able to estimate the number of attempts at suicide that would have been attempts that would have been responsible for that particular distribution of suicides by those methods. And bottom line is, we determined that for every 10 to 20 gun removal actions, 1 life was saved in averting a suicide. And you know, if that might be high or low depending on how you think about the Second Amendment, but you know, if you're 1 degree of separation away from a tragedy of a gun suicide, as I am and many others are, we might think about it differently, and that's the information we want to put in the hands of policymakers to understand what's in the balance of risk and rights.
So was the law, in your view, effective then? Were there drawbacks to it?
Well, you know, I think it was effective. I mean, we estimated that, you know, it saved many lives, and in particular saved 1 life for every 10 to 20 of these gun removal actions. A lesson, though, about this really has to do with implementation, because the law was enacted in 1999, and for the 5 years after that, almost nothing happened in terms of use of the law. Very, very few cases. And then, you know, for a number of reasons, in about 2007 or 8, after the Virginia Tech shooting, the use of the law really picked up, and so that then you had, you know, 100 or more cases each year, and even more than that. So there has to be a very systematic effort to implement the law to make sure that people who are in a position to use it know about it. That's law enforcement or family members or others. So that, you know, it could be because there's information that folks might have about an individual, whether it's someone who's really impulsively angry and is, you know, stockpiling guns, or whether it's, you know, granddad who's bereaved and drinking heavily and he has guns and he doesn't want to, you know, get rid of them. So that this could save lives in those kinds of cases.
Is there any data to support the effectiveness of these laws in curtailing homicides or mass shootings?
Well, that's a harder thing to prove. Homicide is, you know, has a lower incidence, but I can tell you that in Connecticut, when we matched all of the arrest records, we didn't have any homicides in the population of individuals whose firearms were removed. It's hard to, study something that doesn't happen. Yeah. But, you know, it puts a tool in the hands of family members or law enforcement. I think the case I think of here in North Carolina was when Craig Stephen Hicks killed 3 Muslim young people. He was a neighbor, and people knew he was angry. People knew he was, kind of out of control, and he had all these guns. He possessed them legally. There was nothing that could be done. If North Carolina had a law like this, there would be something to do. I think the important thing to realize in our country, you think about gun violence as a public health problem. Firearms are very prevalent, and they're constitutionally protected. So we can't just do what other countries do and say, let's broadly limit legal access to guns. Gun control here is really about people control and how we identify people who are at such high risk that it's justified to limit their Second Amendment right. That's hard to do, and there's been a lot of emphasis placed on the point of sale, having good background checks. But, you know, in our study in Florida, 72% of the gun suicide decedents would have been legally eligible to purchase a gun on the day they used one to end their life. So you could have a perfect background check system, and it wouldn't have stopped them. This actually provides an opportunity to intervene in people who don't have any gun disqualifying record and legally are possession of guns, and it's done for a public safe, the piece of the puzzle of gun violence prevention that could be very effective, and a lot of states seem to agree it's worth a try. I think there are 12 or 13 states now that have a law like this.
I want to move to Jess Aloe. Part of our mission at the Solutions Journalism Network is to investigate solutions, but also highlight failures of solutions. And you and your colleagues at the Burlington Free Press looked at a homicide, specifically in Vermont, where it was clear the woman's ex-partner was violent and had threatened her. Vermont had just passed a version of this kind of gun violence restraining order when this happened. What did you find in your reporting in terms of why that law didn't protect her?
Well, that was a very tragic case where the person who is believed to have done it, who has not actually been found, it's been about 6 months, and they're still not sure what happened to him, had decades of history of domestic violence issues. The woman who died was reporting that the week of, days before that, he was threatening her with the gun. And Vermont had just passed an extreme risk protection order law in response to a very near miss with a school shooting the day after Parkland. But it was modeled after the relief from abuse orders process, where, and what was different about the extreme risk protection is that a prosecutor brings the charge forward, but it still really relies on the witness to tell what happened, to prove to the court that this is a real risk. And in some cases, you have a very public event that happens. But in domestic violence cases, they're often behind closed doors, and you are asking the person most at risk to put themselves even further at risk by going and testifying in court. And they may have, they may share children, they may have, they may live together still, they may have just an emotional attachment, and there's various reasons why that makes it really much more difficult for this to be used. So it faces the same problems as the restraining order process does in terms of domestic violence. And also, it's really difficult in Vermont for to actually enforce these orders.
Oh, why is that?
So Vermont has some of the most permissive gun laws in the country. It is one of the only states where you don't even need a concealed carry permit. It's called a Vermont carry, and the Vermont Constitution is considered to be your permit to concealed carry until recently, which was when after this near-miss school shooting, they had you could go buy a private gun sale without any kind of background check, not even really showing ID. So when you get the order, it really relies on who's going to actually turn the guns over. So the police can say, we're going to serve this order on you, you have to turn your guns over. But if they are resistant or they don't, then that makes it much harder for the police to actually carry that out. It's unclear whether, how they actually can search to make sure they have all the guns. Nobody knows how many guns a person owns, and there's no, the guns don't have a permit, so you can't say, it's hard to say whose gun that is. They can say, oh, that's my dad's gun, my brother's gun. And so it's just, they're so freely easy to get here that it's hard to effectively take them away.
You also, in your reporting on this, you looked at something called a lethality assessment that police can do with victims of domestic violence or family violence. And it could have helped in this situation. Just why would this perhaps have made an extreme risk protection order more effective in Vermont law?
So the lethality assessment comes from the Maryland Network Against Domestic Violence. And it's essentially a screening tool. It's a series of questions that, and if a person kind of ranks as being likely to be killed, and some of these questions are things like, is my partner stalking me? Do I think he might kill me? Does he have a gun? Then that can connect the person with, first of all, it's designed to sort of help the victim themselves realize how much danger they're in. And it also mandates that the police call domestic violence advocate, to help that person, to talk to that person. And so that can help people who may feel like they don't have the option to go to get a restraining order or get an extreme risk protection order, to understand the process and help them navigate that and understand that this is an important part of safety planning. And it's one of those things where it's really dependent on the culture of the police to make sure that this is being done consistently.
I want to turn back to Kimberly Wyatt. After the most recent mass shooting in Thousand Oaks, there were stories about California's red flag law. Wyatt didn't work in that instance. Some articles speculated family members didn't know the option was available. It seemed to be used unevenly in police departments across the state, and efforts to expand the law actually a couple years ago, so more people could have reported concerns about someone, failed. So I'm curious, what kinds of challenges have you faced in Washington state to implement the ERPOs?
One of our most recent discussions is, does the extreme risk protection order apply to juveniles in the context? And I can say that our statute in Washington state is silent on that issue. And it's difficult to know exactly, and I believe a legislative fix is probably likely underway, but it came up in the context when we would go out to train or talk to law enforcement. And certainly after Parkland, we were getting consulted on several school threat cases where perhaps the juvenile has been charged actually in juvenile court. And we don't believe that juvenile has actual firearms because they can't possess firearms if they're under 18 in Washington. They could not get a concealed pistol license unless you're 21 in Washington state. But our concern was, what do we do about the parents or guardians that we believe, based on either firearm purchase history, so there's no registry, of course, but Washington has certain handguns that are supposed to appear in purchase history or concealed pistol license. So we had information that family members, specifically fathers, had firearms. And our concern was, when the parents declined to cooperate with law enforcement and give officers who are investigating the juvenile enough reassurances that the firearms were out of the home, how do we apply, can we get an ERPO on behalf of the juvenile living in a home with access to firearms? So that's an issue we've been struggling with. And I would say another issue too is with our federal partners, can they apply for an extreme risk protection order? We've had some correspondence with the FBI and ATF, and I believe under our statute they can. And there is some concern about whether these extremist protection orders are also hitting the national databases, mainly the NICS index or indexes, which I believe is the index that's maintained by the FBI when they go and do background checks from a federal firearms license dealer.
Oh, so they have that. You don't know if they have that information when they're...
Well, yeah, I believe it's supposed to be hitting their NCIC, which would be our nationwide criminal history. So once an order, similar to a protection order in a domestic violence case, those are supposed to go into place nationwide in the system. So if law enforcement had contact in a different state, they would see that this is a person who's prohibited. We have concerns of whether that is showing for these extremist protection orders as well. So that's another concern. And I'm trying to think of some other big issues that have come up.
Do you think the police have pretty much adopted these and bought into it? It seems like implementation is key. I've heard everyone say this.
Yeah, I would definitely tell you that it takes a partnership, and I would encourage law enforcement to partner with their local prosecutors, whether that's the city attorneys or your county prosecutors, so that you are doing this as a team and that you are guiding through these steps together, because law enforcement, especially legal counsel for police departments, are very nervous about the implications of doing this. And I can say to date, there's a lot of thought that goes into the process with law enforcement when they go to serve somebody with these orders, because obviously here you're getting a court order that says this person is an extreme risk to themselves and others, and they have firearms, and we're going to send, patrol out to enforce it. So law enforcement, at least the ones that we have walked through the process, once we've gone through it, I think that they would say that this is an effective tool. There's just a lot of hesitancy in doing that because it's unknown. And to also see that it's not a gun grab. There's plenty of cases that, we're vetting some, and certainly police departments that we're not pursuing extremist protection orders on. And so I think once people read the petitions and actually see the cases that are coming forward, I think they would be surprised to know that those individuals could have firearms, quite frankly.
I saw the wonder of Zoom. I saw Jess nodding. There's sometimes it's a challenge with police to adopt this. Is that something you saw?
Yeah, and I mean that the reluctance to the complications is definitely something that's come up. There's a lot of concern among law enforcement about what if they're legally liable for destroying a firearm, losing a firearm. What do they do once they have it? Has been a big concern, as well as are we going to overstep our boundaries if we go and try to take them, if someone's resistant. And, this is still very new law, but in Vermont, you have quite a few people who are very avidly pro-Second Amendment and find this to be an infringement on their rights. And so are sort of looking for opportunities to challenge it legally. And so there's a lot of concern about that. And then just, what do they do with the guns once they have them has also been a concern they've faced. And so that's really, we've seen that the prosecutors might be willing to try these orders or try to go for an order that would remove the guns, but then it's up to the police to actually implement it, and they have a lot of concerns, and it's still not clear exactly how that should look. So.
Kim, I wanted to go back to you. You mentioned your first comments about it's great as a prosecutor to sort of be on the front end of before a crime occurs, but that some people are kind of bringing up parallels to the movie Minority Report with these laws, like you're essentially punishing someone for thinking about doing something. So how do you balance protecting the public and protecting gun rights and civil liberties?
I would say that this is not just the prosecutor's office or law enforcement, that obviously it's coming before a court, so there's due process built in, and then it's up to the judge, really. I mean, we may petition, and we've had, I believe of all the orders we've had issued at the emergency phase, they've all been issued, but we've had at least 5 or 6 that were denied at the full hearing out of 60-some extremist protection orders that we have assisted law enforcement with over the past year. So I would say that there is due process built in there. And to your point, I would say we've had various respondents, so those that are subject to the extremist protection order, come before the court and tell the court that they were thankful that law enforcement intervened. It was the first time I've ever really seen that in my work. And it was pretty powerful and moving, and including an individual who shot himself in the chest, you know, fought with law enforcement when they arrived to render aid. And he later came in, he was at the full hearing, IRPO hearing, and thanked law enforcement in open court and told the judge that, you know, this particular order saved his life. So that's kind of how I would rationale that, balancing it. We're trying to intervene. It's civil, it's temporary. So this is not a lifetime ban on firearms. And there's due process built in.
These are you're taking away temporarily. Most of these laws are structured.
Yes,
like, okay.
That's true. At least ours is. It's not a permanent ban.
Jeff, your research in the cases of suicides, it's not uncommon for friends or even close family to be surprised when someone actually does take their life. How can these laws be effective in those situations?
Well, they can't stop every suicide, but, you know, suicides where a person does exhibit some warning signs and people close to them are aware of that, and a firearm is involved. You know, people who try suicide on average with anything else are very likely to survive and have a chance to get help. And if they use a gun, they almost never survive. The case fatality rate is 85 or 90%. So it's a really good public health opportunity. I wanted to mention just a couple things about issues that have come up in the conversation. One, we did have a couple of cases in Connecticut where the person of concern was a juvenile, was a minor, living in a home where, of course, they couldn't legally own guns, but the guns were owned by their parents or their guardian. So that was done, although in our key informant interviews with some of the judicial officers and judges and people, we found a difference of opinion. One of the judges thought that was a legitimate use of the statute, and another thought that it really probably was not the way you would remove guns owned by someone else. And if there's an issue with a juvenile or a minor, that would be a child welfare issue for the child welfare agency. So it is a matter that's a little bit unsettled. I also wanted to mention that I think it is important that when a person is subject to a risk warrant gun removal, and that's upheld, that should generate a prohibitor in the National Instant Check System. In Connecticut, the way it works is that when the risk warrant is issued, that generates a prohibitor that's sent to the Special Licensing and Firearms Unit that makes that person ineligible to purchase a gun for the duration of that risk protection order. I think that's important too, because if someone's guns are removed and then they just go and buy another one, it wouldn't be that effective. So, and the other thing with regard to due process, there is the probable causes standard for removing guns and securing them, kind of in the moment, and getting that initial ex parte order. But there is a hearing, as we've said, in Connecticut. It has to happen within 14 days, and the state has the burden by clear and convincing evidence to show that this person meets the criteria. Then the judge makes that decision, and it is time limited. And actually, if we look at the polling data across the spectrum, gun owners and non-gun owners, people who members of the NRA, by large margins support this idea. And if you think about it, if you're someone who really cares about the Second Amendment and you say, and you've been saying for years, guns don't kill people, people kill people. Well, here's a law that's designed to help identify who those people are. And it's not just applied willy-nilly. So I think it is one of these kinds of policies where even a topic that is as politically radioactive as private gun ownership in our country, where you can get a common, swath of real estate where people can come together and say, yeah, we might disagree on the politics of gun control writ large, but we agree that a person at manifestly high risk of harming himself or herself or someone else shouldn't have legal access to a gun at that time. And then what are we going to do about that? And this provides a tool that law enforcement folks, if you talk to them, as I have all over the country, think that is needed and is helpful.
Jess, do you feel like there's been a shift at all, like what Jeff is describing in Vermont, which is a very pro-gun state.
I mean, just the fact that this law they were able to pass this law, and it was passed alongside a few other gun laws, including one that will allow police to, which just went into effect, allow police to remove guns from a house when they arrest somebody for domestic violence, which, so if they make an arrest or a citation, they can take the guns out of the house then. That one is even newer. And then there was some limitations on the capacity of magazines, and that was all really, really unbelievable for Vermont. I mean, Vermont has been so against any kind of regulation. For example, the city of Burlington, which is the biggest city in Vermont, wanted to change its charter to ban guns in bars. So when you're drinking at a bar, you should not. They wanted to ban it. It went to a vote. The majority of the people in the city wanted that. They said that seems like a common sense thing, but charter changes have to be approved by the state legislature, which did not approve it, even though it was only going to apply to Burlington and was clearly something that people wanted. They said, no, we will not. We don't want to vote on a gun law. And it wasn't really until this near-miss school shooting, which was in Fairhaven, Vermont, and was really a pretty profound shift, to say the least, that they would even consider passing something like this, and that it went somewhere was unbelievable. There was a big backlash. I mean, there were a lot of people who were very upset about these laws, and still are. They have been quieter in the past few months, but there's still a lot of reluctance. There's still a big belief that this does infringe on due process, that this takes away a right, and we haven't seen. We're still seeing the extreme risk protection, them starting to feel out how to use that one. It's been used a handful of times since the almost school shooter, including when there was one recently where a man got into a argument with somebody at a rehab hospital. I think it was a physical therapy type place, and started screaming that he was going to go get guns and shoot people, and that it was used then. But I think in terms of the more everyday places where you might see it used, suicides, domestic violence, they're still starting to shake off the cobwebs and figure out how they can use it in those cases. And we'll see if there's legal challenges or there may be.
Well, we're almost out of time, but I wanted to turn to Kimberly because I know you and Jeff have been tracking these laws around the country. Are you seeing, are these laws prompting that these laws combined with some of the more high profile shootings like Parkland, or is it too optimistic to say there might be a shift in a break in the ice to talk about how we can curtail gun violence because of these?
I think so. I mean, I think this is an incredibly effective tool. We just have to educate the public and law enforcement. And even in our area, I can say that I take calls weekly from law enforcement that have heard sort of about this order, but they definitely don't know about it. So I think that's on us or individuals within your state to really promote it so that people are aware that this exists. And I do think it's a tool. As the doctor said, it's difficult to analyze something that hasn't happened, but I do think it's a critically important tool that we need to educate the public about.
Okay. Were there any final thoughts from anyone that I didn't touch on?
I could just add very briefly, the second state to enact an extreme risk protection order law was Indiana in 2006, which is a very different state than Connecticut. It has a higher prevalence of firearms in the population. It has weaker gun laws overall. It has different profile on gun fatalities, but and it was enacted again out of public concern over a shooting involving a shooting of a law enforcement officer and others. But if you look at the states where these laws have been enacted and are proposed, they really are kind of across the spectrum. And there's been so much pessimism that nothing is happening, even after the Sandy Hook shooting at the federal level. Comprehensive background check failed to pass. But if you look at the state level, where people actually have a greater opportunity to influence their state legislatures, there's been a lot of activity in this area and in others. And more than half the population of the United States now lives in a state that has, you know, stronger and I would say more sensible gun laws than before the Sandy Hook shooting. So I think from that point of view, you know, and there are laws that would work better at the state level if we had universal background checks. But I think there is reason for some optimism.
I just also want to say that when it comes to the domestic violence, especially, there's a lot of potential, but in places like Vermont, where there is a really cultural reluctance sometimes to come forward with these things that they have behind closed doors, really needs to be something that they look at as a holistically in terms of also providing housing resources and economic help and transportation. And it can't just be, well, if she doesn't want to come and make a statement to the court, then we can't do anything about it, because that's what happened in this case with this woman, where she had her reasons for wanting to be reluctant to go to the court, and once the police heard that, they were like, there's nothing else we can do, we're done. And so that makes it, I think, it has to be a kind of a holistic to make these really be as effective a tool as they possible when it comes to domestic violence victims.
Well, I want to thank you all so much for participating in the Solutions Journalism Network presentation. We'll be posting this conversation online, and we can put in additional resources that if any of you want to send those to me. But thank you very much.
Thank you.
Great. Thank you very much.